of Sunnah in the Muwatta of Malik ibn Anas by Mohammed Yusuf Guraya. Mcgill University, 1969. Conclusion. Sunnah and hadith are not identical in the Muwatta. Hadith in general certainly is one of the sources of Sunnah, but not its only source. The acceptance of hadith by Malik as a source of Sunnah does not depend upon the principles enunciated by later specialists on hadith. For him, all kinds of hadith such as the musnad, the mursal, the mawquf, the munqati', etc. are equal as legal arguments. They are accepted or rejected, and they are also superseded by one another, indiscriminately and on the basis of principles other than those developed by later scholars in the science of hadith. The past is whatever form, i.e. statements, verdicts, decisions, etc., by the legal authorities of Medina, is another source of Sunnah in the Muwatta, but the past as such is not an independent legal argument. Its validity depends upon its bearing on the present. Acceptance or rejection of the authority of the past will be judged, regardless of the source of information, by the extent to which it is useful in present circumstances. The present or the prevalent practice of the people of Medina, al-amr alladhi adraktu al-nas, is another important constituent of Sunnah in the Muwatta. Apologies, Arabic text not given. The present is not dependent upon the past for establishing its validity. Rather, the present is so independent of the past that sometimes the latter is judged by the former. Traditionally, it has been held that the practice of the people of Medina, al-amal, was the highest legal argument and the final standard of judgment with Malik. We have shown that although the amal ruled supreme over legal arguments, it was not the final standard of judgment with Malik. Truly, it superseded the past, and never vice versa, but the amal in turn was superseded by another yet higher argument, i.e. the personal judgment of Malik himself, i.e. indana. Very extensively used expressions in the Muwatta, such as al-amr al-mujtama' alayh عندنا الأمر الذي لا اختلاف فيه عندنا الأمر الذي أدركت عليه على الأهل العلم ببلادنا. Apologies, no Arabic given and very poor transliteration. Have traditionally been taken in the sense of the general consensus of the people and of the scholars of Medina. We have established on the contrary that in spite of these bold phrases, Malik did not mean by them the actual general consensus of the people or of the scholars of Medina. Rather, he applied these suggestive expressions in his endeavour to bring about a consensus and to point out a normative practice. The possibility of an actual general consensus or practice of the people of Medina and the Muwatta cannot be ruled out altogether. Establishment of such general consensus does not depend, however, upon the use of the foregoing expressions with their corroborative phrases, apparently convey this sense, to establish the actual consensus or practice on a particular issue. The following conditions have to be fulfilled. 1. No hadith, statement, verdict or decision, etc. of any of the past authorities quoted by Malik against the issue. 2. The expression employed by Malik to describe the issue reflects the general practice of the people of Medina. 3. The scholars of Medina agree with the issue. And 4. Malik with his circle, Indana, agrees with the above conditions. Thus, hadith from the Prophet or from some subsequent authority, administrative directives, authoritative legal and juristic statements, verdicts and decisions of the past and the present authorities and customs and practices of the people of Medina, i.e. the prevalent legal material in Medina, are all legal arguments with Malik to be used to support a particular view of Sunnah. This view of Sunnah rules supreme over these arguments and constitutes the highest and conclusive standard of judgment with Malik for evaluating and assessing the material and presenting a normative practice. We have therefore concluded that the Muwatta, instead of being a simple record of the consensus and practices of Medina, is an endeavour to bring about an ideal consensus and a normative practice. The original meaning of the term Sunnah, as we have seen in chapter 1, is to set an example and to introduce exemplary conduct. In the context of the Muwatta, Sunnah means to bring about and to point out from the prevalent legal material the exemplary conduct and model behaviour introduced by the Prophet. We have also seen in the same chapter that the exemplary conduct of the Prophet in the form of religious and ethical principles became established, and this fluid and liquid concept began to crystallize in the shape of definite rules and usages of the community. It was the function of the early jurists and scholars to find out and to point out this exemplary conduct from the cumulative tradition and from the accretive legal material. It is in this context that the term sunnah has been employed by Malik in Muwatta. The meaning of sunnah is further strengthened by the corroborative expressions indana suffixed sunnah. Contrary to the traditional interpretation, we have shown in great detail that indana means Malik and those who held his opinion. Malik's occasional use of indi in the place of indana has made this meaning all the more clear. It is through this combination of sunnah and indana that the concept of sunnah in the Muwatta is established. There are some other expressions also employed by Malik in his Muwatta to convey this concept. They are ذَلِكَ أَحَبُّ مَا سَمِعْتُ إِلَيَّ فِي ذَلِكَ. This is the best of what I've heard in this connection. Apologies, no Arabic given. La ba'sa bihi, there is nothing objectionable in it. Ara, this is my independent considered opinion, etc. Therefore, the content of sunnah, the normative practice of Malik, is not identical with the concept of sunnah as understood by Shafi'i. Rather, the concept of sunnah indana is 1. The religious ethical principle introduced by the Prophet, which in due course of time had acquired the status of recognized Islamic religious norms and the accepted standard of conduct. 2. Sound reason and independent considered opinion. And 3. Legal and moral reasoning. The intellectual activity of the Medini scholars in the generation preceding Malik was in the field of fiqh, pure and simple. Due to their rational, legal, free thought activity, they were known as the fuqaha. They had little to do with hadith. With all its latter technicalities, Malik was brought up in this intellectual milieu and received his training in this environment. Consequently, he started his intellectual career as a jurist, and the contents of the Muwatta bear witness to the fact that he continued his career throughout his life. But the period in which he lived was gathering momentum in favor of hadith. He shows his awareness to this fact, but is content only to use it as one of his arguments and not beyond that. He rarely invoked the verbal transmission of sunnah, i.e. hadith, to establish his point. It is true that he utilized the hadith material more than his predecessors, but that was due to the fact that the pressing need of the time for uniformity and standardization amidst the chaotic and confused situation created by legal divergences compelled the scholars to meet the challenge on an empire-wide level, as the previous scholars had done on the regional level. Malik shows his awareness of the ultra-regional evolution and used hadiths in his argumentation, which was acquiring the status of the universal element acceptable to all regions. This development was in contradistinction to the pure fiqh which developed regionally in geographically and socially closed areas. Despite this evolution in his legal thought, ironically, Malik is more conservative to the genius of his predecessors than his counterparts in Iraq, Abu Yusuf and Shaybani. The overriding authority accepted by Malik was not the hadith, but the sunnah indana, whereas the Iraqis, especially Shaybani, had gone halfway to Ashraf in the utilization of hadith material in their argumentation. End of thesis. Stay tuned for many more parts.